All right, good morning. Welcome to the 294th District Court. I'm going to ask you today to make sure that you maintain social distancing, make the entire use of the courtroom if you can. If you're a family unit, you can sit together. If you're not, spread out. I encourage you to wear a mask. If you do not have a mask and you would like one, just ask court staff, the bailiff, and we'll assist you with one. Please maintain social distancing in the hallways and the restrooms and the common areas in the courthouse. When I call your name, I want you to please say present or here and raise your hand so that I can see you and hear you and mark you down on the docket. William Ivy. Dash Moore. Present. David Nichols. Present. Tracy Chastain. Justin Devine. Present. Candace Munoz. Jeremy Hendricks.
Here.
Robert Kane. Here. Lindy Delaney.
Your Honor, she called our office this morning and she told us that she's running about 30 minutes late. Hard verbal.
Thank you, Mr. Marluder. Anthony Davis. Here. Christopher Fields. Here. Austin Harris. Christopher Templin. Jacob Howell. Brittany Alvizo. Scott Bowden. Nicholas Fincher. Marcus Fowler. Ivan Rostro Garcia. Mitchell Autry. Willie Jopling. Katrina Lambright. Dustin Sorrells. Right, when I call your name, I want you to come up and have a seat in the jury box so that you can speak with pretrial services. Justin Devine. Scott Bowden. Ivan Rostro Garcia. And Marcus Fowler. Just stay spread out in that jury box. Ms. Burns, these are the individuals who are either delinquent in their pretrial services fees or they've failed to report as ordered. I'll ask that you address that with each one of them, and then I'll recall their case in just a moment. Counsel present in the courtroom, do we have anyone that's ready? Ms. Beasley?
Supposed to be appearing by Zoom, but she has 102 temperature this morning and throwing up.
You know, I see that there's someone logged in as iPhone, but I don't know if that's her, and I'm real leery about bringing people into the courtroom if I don't have their name and their device. You want me to bring in the iPhone and see if it's
yes,
her?
sir, if you don't mind. Did send me a picture of her temperature. Wasn't just claiming that she's sick. She did send me a picture.
Ms. Freely, I'm gonna need you to unmute your device so that you can be heard, please.
Is it working now?
Yes, it's working now. All right, court calls cause number CR 19-231, State versus Jaden Danielle Freely. We're set today on a status hearing regarding the discharge from the pretrial intervention program. Ms. Beasley?
That is correct, Your Honor. I've been able to consult with Ms. Hillary, and we've been able to resolve it. We were hoping to get it resolved today, but obviously with my client running 102 and throwing up the last couple of days, I've advised her not to make a physical appearance in court.
What's going to be the disposition?
We're gonna move forward with an amendment to the conditions of probation and put her back on the PTI program, let her finish out that program, Your Honor.
They're going to require a court amendment?
Yes, she will appear. It's gonna have, do we decide a weekend? Is that what we decided?
We did, it was going to be tomorrow, but we'll have to reset that weekend that she's going to serve as a sanction.
Are you available on December 15th, Ms. Beasley?
The 15th, Your Honor?
Yes, ma'am.
Yes, Your Honor, I am.
All right, Ms. Freely, we're going to set your case for status on PTI on December 15th at 9 a.m.
Yes, sir.
This will be the only notice that you receive from the court, and I hope you get to feeling better.
Yes, sir. Thank you so much.
In contact with Ms. Beasley, your attorney, will see you on December 15th.
Thank you.
May I be excused, Your Honor?
Yes, thank you, Ms. Beasley. Mr. Schmidt, are you ready?
I am, Your Honor. Austin Harris, pretrial.
CR 2166, Austin Harris.
Would you like him to approach, Your Honor? Or?
Yes, the middle podium. Go ahead, Mr. Schmidt.
Your Honor, we're set for pretrial today. I have no contested pretrial matters. I am in discussions with Ms. Curry about this case, and I'd ask that, if possible, we set it for a status on that on December 15th, if that's available. My understanding is that was a potential court date.
What's the status for?
To see if we reach a plea agreement. I'm not sure. We're in plea. I don't know what you want to set it for, but.
I would just set it for docket call.
Oh, okay. Oh,
So then he can announce that day if he's going to
Yeah, sure.
work something out, or set it for a bench trial or jury trial.
okay.
All right, Mr. Harris, court sets you for docket call on December 15th at 9 a.m. Mr. Schmidt's going to provide you a notice of appearance. Once you sign and receive the yellow copy, you'll be free to go.
And you have a seat in the back, Your Honor, and I'll give him, he signed, but I'll give him a copy that has the date on it.
Yes. And Ms. Friedley, you're free to go. You can turn off your device. Are you ready on Templin?
I am, Your Honor.
Christopher Templin, if you'll make your way to the center podium, please, sir. Mr. Templin's also set for pretrial.
He is, Your Honor. I did file a motion to suppress after reviewing the video. I've spoken with Mr. Cox. I feel like there's a high chance that we'll resolve this case without a contested hearing. And so I know that the court has a contested docket on December 17th. I do have with that date. My thought would be to set it for a status if possible. And if we need to set the motion, we will, but I'd say there's probably 90% chance we won't have a motion for a hearing. So I don't know if you want to do that same date of December 15th.
So you don't want it setting on your motion to suppress?
Well, I don't want to set it when I think there's a good chance we'll resolve the case and the state have to subpoena witnesses. We are in some discussions, and I know they want to watch the video and look at the issues I've raised, but
Any objection from the state? If the court sets Mr. Templin for docket call on the 15th, and if he changes his mind, allow him to set for a motion express after that.
No objection, Your Honor.
All right, court will set Mr. Templin for docket call on December 15th. At 9 a.m. Mr. Templin, once you receive the yellow copy, you'll be free to go.
May he have a seat, Your Honor.
Yes, make sure he gets the yellow copy, court gets the white copy.
Thank you, Judge. That's all I have this morning. May I be excused?
Yes, sir, thank you.
Appreciate it.
Wine, are you ready?
Yes, Your Honor. Page 4, Jacob Howell.
CR 2083, Jacob David Howell. If you'll come to the center podium, please, sir. Mr. Howell set for docket call today.
He is, Judge. I was retained within the last couple of weeks. I have made plans to pick up the discovery in this case as soon as I leave the courthouse. So I'd like to set it for either a pretrial or status once I've had the ability to review the discovery, and we can go from there.
Who was Mr. Howell's counsel before?
Mitch Adams.
Have you received any discovery from Mr. Adams
I have
regarding
not.
the digital? Did you request it? Or?
I did send him an email, but I have not received anything. I didn't request the discovery from him.
All right, court will set Mr. Howell then for pretrial on December 15th. And Mr. Howell, once you sign the yellow copy, once you sign and receive the yellow copy, you'll be free to go.
Thank you.
Mr. Hughes, are you ready? Sir, you are? Okay. You'll just come to this podium right here.
Yes, sir. Yeah, you can use that.
Yes, thank you, Mr. Weiner. Robert Kane, CR 226. Mr. Kane is set for docket call today. Is that correct, Mr. Hughes?
Yes, Your Honor, it is.
Any announcements?
Yes, Your Honor. We're going to file a waiver of, if I may approach.
Yes, sir.
A waiver of jury trial and then reset for the plea itself at the day that is convenient for you after the first of the year.
Mr. Hughes, I'll give you this back and you can write in that date. We'll discuss that in just a moment. Mr. Kane, if you will, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. You are Robert Paul Kane, is that right?
Yes, sir.
And Mr. Kane, you have signed a waiver of jury trial document today with your attorney, Mr. Frank Hughes, is that correct? And have you and Mr. Hughes discussed that you have the absolute right to have your have your case tried before a jury of your peers?
Yes, sir.
You understand that within that right, you also have the right to subpoena witnesses and cross-examine and confront the state's witnesses during that trial by jury.
Yes, sir.
You understand that no one can take that right away from you, but you can waive it. Are you waiving this? Are you requesting the court to allow you to waive this jury trial of your own free will?
Yes, sir.
Are you doing so intentionally, knowingly, and voluntarily?
Yes, sir.
That means no one's forced you, pressured you, or made you feel like you had to waive your right to a jury trial.
No.
You're asking the court to approve the waiver today. Is that correct?
Yes, sir.
All right, the court will take judicial notice that this document states that the attorney for the state and attorney for the defendant have joined in with the defendant in requesting this waiver. Court hereby approves the waiver of jury trial in Mr. Kane's case. And Mr. Hughes, you said you would like a setting after the first of the year.
Yes, Your Honor.
Any objection to this state?
No, Judge.
Mr. Hughes, are you available on January 19th?
Yes, I am, Your Honor.
All right, court sets Mr. Kane for his plea on January 19th of 21 at 9 a.m. Once you've signed the form and received the yellow copy, Mr. Kane, you'll be free to go.
Thank you.
Are you ready?
I'm ready for all of them, whenever you are.
Mr. Hughes, is there anything else? Mr. Hughes, anything else at this time?
No, Your Honor.
Thank you, sir.
Your Honor, if you're looking for someone, we're ready for an announcement anytime the court is.
Okay, I will. I've got a packed courtroom, so I need to clear some of these people out.
Understood, Your Honor.
I'll be right with you. Mr. White?
Yes.
Mr. Jopling, just stay where you're at. That's fine. Just stay right there. Can you hear me okay? Yes. All right. And it's my understanding, Mr. Jopling, that you may have a family member who's experiencing symptoms of COVID or may have been confirmed. Is that correct? Okay, just as long as you can hear us right here, Mr. White will speak into the microphone.
Yes, sir.
As will I. And we're set for docket call today, Mr. White.
That's correct, Your Honor. I talked with Ms. Heisel earlier in the week on this. We're going to ask the court to set this for a plea. There's going to be a monetary obligation on some restitution on this that is not an insignificant amount. And if the court wants to set it for like 30 days, we're okay with that. We're hopeful that we'll be able to get the money together in that period of time.
You available on December 15th?
Yes, sir.
All right, court will set Mr. Jopling, and you want it set for a plea on that date, Mr. White?
Yes, sir, please.
Court will set Mr. Jopling for plea on December 15th at 9 a.m. All right, Mr. Jopling, once you sign and bailiff gives you the yellow copy of the court's finished with you, Mr. White may need you further, I'm not sure, but you'll be free to go as far as I'm concerned. Katrina Lambright. Ms. Lambright, if you'll make your way to the podium. This is CR 20-175-176.
Yes, sir. Early in the week, Ms. Heisel and I discussed this case. Ms. Heisel made a offer on behalf of the state. I think if the court would want to give us one more docket call, that would be beneficial in being able to work this out.
Any objection from the state?
No, Your Honor.
All right, court sets Ms. Lambright for an additional docket call on December 15th at 9 a.m. All right, you're free to go. Dustin Sorrells, CR 2090. Mr. Sorrells set for docket call, Mr. White.
That's correct, Your Honor. This is the same announcement. We're trying to work through this case. I think another docket call would be beneficial to both parties to try to work this out without any sort of contested matters.
Any objection from the state?
No, Your Honor.
All right, court sets Mr. Sorrells for December 15th for docket call. Anything further, Mr. White?
No, sir.
All right, Mr. Harrison, are you ready on Mr. Hendricks?
Your Honor, the court would be familiar with the tortoise and the hare. We are more tortoise today. We are making slow and steady progress. I spoke to Ms. Curry yesterday. She asked that I request a little more time, possibly the December 15th setting. I do think we're going to have a resolution, and I hope to have it on that day or by that day.
Where are we at on Mr. Hendrick's case as far as court settings go? Are we past pretrial? Are we on docket call? I see we're set for status. I'm not sure what I'd have to go research to see what our status is for.
Judge, last time we were on a status, we had a plea offer that was, I won't say it was pulled, but it was under reconsideration, and it's continued to be under reconsideration. We've provided Ms. Curry with additional information. And again, I think we're moving in the right direction. I think we'll have it resolved, but I just can't make that announcement yet. And she requested we ask for an early December setting.
See, we've had three trials and a plea, and status in October and a status in November. So what I'll do is I'll set it for a final docket call on December 15th, and we'll need to have either a resolution or set it for trial. But we'll set that on December 15th for a final docket call.
Yes, sir. And I'll stay in touch with Ms. Curry.
All right, thank you, Mr. Harrison.
Thank you. That's all we have. May we be excused?
Yes, sir. Thank you. Good to see you.
Nice to see you, Judge.
Mr. White, are you ready?
I'm ready on 5 and 6.
Okay. Who are you ready on first, Mr. White?
I guess we can just go down the list on the order.
Yeah, you tell me. You said 5 of the 6. So you either tell me who you're not ready on, I'll call the others, or tell me who you want to call.
I can Garcia, I've got the paperwork, we just have everybody sign it.
Okay. Ms. Alviso, CR 2100.
Your Honor, I received a plea bargain earlier in the week. I think that we are very likely to take it. If we could just have this reset for announcement or plea, I believe this will be resolved next week.
All right, court will set Ms. Alviso for another docket call on December 15th. Yes, you're free to go. Scott Bowden. All right, Mr. Bowden is set for docket call today.
That's correct, Your Honor. We are asking for one more resetting. Our situation is not so much a resolution as much as it is trying to get a determination of the restitution amount. Not trying to get the money together at this point, but just what is the final amount we're looking at.
And Judge, I believe that Mr. White and I have an agreement on this case absent the restitution amount. I've had several meetings with the victims, and we are trying to get a nailed down final amount for them because the value of the cattle that was stolen is slightly contested. So we are asking for an additional docket call for us to get a hard number from our victims so that we can complete the plea agreement.
All right, the court will set Mr. Bowden for docket call on December 15th.
And we'll call them and get you an answer quickly.
You're free to go. Nicholas Fincher. Mr. Fincher is also set for docket call.
Your Honor, we have a situation where I can 99% say we would be needing to set this for a plea.
Would December 15th be a suitable date?
That would be great if we could keep them all on that day.
All right, Mr. Fincher, the court's going to set you for plea on December 15th at 9 a.m.
Or just email Stephanie and copy me on it. Or call Stephanie.
Mitchell Autry.
I mean, I can sign off on it.
Okay, 376 dash more.
Dash Moore, CR 16376. All right, it's my understanding, then, Mr. White, that you've been retained to represent Mr. Moore.
That's correct.
Court will reset this for a hearing on Mr. Moore's motion to revoke on December 15th. And Mr. Moore, I would just remind you that you're still on community supervision, still required to report, to pay, and be in compliance. I'm sure Mr. White would appreciate you doing the same. Makes his job a little bit easier.
Your Honor, if I could, I could be able to get the paperwork done on that plea. I'll be back.
Yes, yes, thank you. Christopher Fields, you'll make your way to the podium, please, sir. Morning, Mr. Sierra, how are you?
Good, Judge. How about yourself?
I'm fine. Well, let me make sure that I've got your name. Is it Rafael Sierra?
Yes, Your Honor.
Okay, good. And Mr. Fields is set for docket call today, I believe.
That is correct, Your Honor.
Been able to reach any agreement with the state, or is there a request for a bench trial or a jury trial?
Your Honor, my client is prepared to accept the state's offer, but we respectfully ask if you would allow for a December 15th plea date. Mr. Fields wants to take care of some loose ends in his household before he resolves his case.
Okay. So I'm assuming that this is a disposition for time.
Yes, Your Honor.
Is there any discussion between the state and defense regarding waiver of jury trial, or you're comfortable with Mr. Fields just coming back on December 15th to enter his plea?
I'm comfortable with him coming back in December to enter his plea.
Okay. All right, then the court will set Mr. Fields for plea on December 15th we're going to set that at 1:30, Mr. Fields, and that will be out at the Van Zandt County Justice Center, out at the jail. Okay, so if you're going to go into custody, we'll just have you come in the afternoon. That way it's not in the morning. All right, so the bailiff's going to have a notice of appearance. If you'll just sign there, and we'll give you a copy of that form. Mr. Fields, do you anticipate being in person that day? Okay, and what about you, Mr. Sierra?
Your Honor, remotely.
Okay, and so you're going to work with the state on getting the plea papers executed and have your client admonished and signed for your.
Yes, Your Honor. I have every intention in reaching out to Mr. Cox, acquiring the paperwork, meeting with my client in the office, and then submitting that to back to the state, Your Honor.
Okay. All right, Mr. Fields, free to go. We'll see you back on December 15th, 1:30.
May I be excused, Your Honor?
Yes, thank you, Mr. Sierra.
Thank you, Judge.
The audio is now good. But I can't hear.
How about now?
Absolutely great. Yes,
All
sir.
right. Mr. White, can you I'm sorry.
Yes,
Can you
sir.
repeat that?
I've had the opportunity to talk with the state about Mr. Autry's case. We feel that if the court gets to December the 15th, we'll come up with a resolution on that day. I figure the court, because of that, the court will order, I think the state would want Mr. Autry to appear in person on that day.
Any objection from the state?
No, Your Honor, Mr. White, we agree with Mr. White.
All right, the court will set Mr. Autry for plea on December 15th. Mr. Autry, you must appear in this court in person on that date. Failure to appear on that date will result in the court issuing a warrant for your arrest. Do you understand that?
Yes, Your Honor.
And I'm also going to order you to stay in strict compliance with contacting your attorney, Mr. White. And I also want you to touch base with your bondsperson, be in compliance and contacting each.
Yes, sir, Your Honor.
All right, so this will be the only notice you get from the court. I'm telling you, December 15th at 9 a.m., you're due here in this court.
Thank you, Your Honor.
All right, you're free to go.
That's all I got to say.
Thank you, Mr. White. Mr. Murley, are you ready?
Yes, Your Honor.
And is Ms. Delaney here?
Yes, Your Honor.
CR 20-9, State versus Lindy Delaney. Ms. Delaney is set for docket call today.
That's correct, Your Honor. At the last docket call, Judge, we announced that she has an outstanding second-degree felony unindicted possession case. We were resetting that case so that the state can get the labs, decide to indict that case. I spoke with the state counsel, Ms. Heisel, this morning, and she stated that we still do not have the labs for that, and they're still planning to go forward on that case. We'd ask for a 60-day reset, Your Honor, so that you can get those labs and proceed on that case.
My concern with setting it out that far, Mr. Mayor Leader, is that my records indicate that Ms. Delaney hasn't reported on pretrial release since September, and that she's delinquent nearly $500 on her attorney fees and supervision fees.
We've instructed her, Your Honor, to go to pretrial right after this to get her fees and reporting taken care of. The last court date we had, I believe, was in September. So we didn't have a court date for October, I believe. So if the court wants to set it for, say, December 15th, that's fine as well. I just wanted to set out the time a little bit further just so that the state can get the labs back.
And we do need to understand, though, that if she doesn't have a court date for 60 days, that means she doesn't report for 60 days. That means she still has to report monthly as ordered. If she doesn't have a court date, she has to go to the pretrial release department and report, get a drug test, and pay. The objection from the state? All right, the court will set Ms. Delaney for docket call on January 19th. Ms. Delaney, there is a warrant for your arrest. There's a surrender of principal warrant, meaning your bondsman has surrendered you. So you're going to be taken into custody at this time.
Is that on this case?
I don't know. The bailiff may know once she's done, but I just have surrender of principal warrant. William Ivy. This is CR 19 313, 314, 315, and 316. Mr. Ivy, am I understanding correctly that you are intending to retain an attorney to represent you?
Yes, sir.
And do you know who you're going to retain?
I've been trying to get ready for a surgery, so I've contacted somebody, but they haven't contacted back out of Athens. Things
And when are you going to be able to retain this person? Have them hired? You're facing 4 second-degree felony charges that carry ranges of punishment of up to 20 years in prison. So I want you to understand the gravity of this situation.
there's some factors that play into that case.
I understand, but from my perspective, I can't allow you to just, I'm going to hire somebody, I don't know who it is, and I don't know when it's going to be. I need some concrete details.
I'm hoping by December 3rd.
So if I reset you for December 15th, you believe that you can come back with an attorney?
Yes, sir.
All right, Mr. Ivy, I'm going to give you that opportunity. I'm going to reset your arraignment for December 15th. Okay, you fill that out while you're dealing with. Sure. So, Mr. Ivy, we're going to provide you a notice of appearance form with a reset date of December 15th. We're going to have you sign that. We're going to give you a yellow copy. Then you'll be free to go. Take that copy with you or send it to the attorney that you're going to be retaining so that they're aware of the reset date and what it's for, arraignment on these charges, okay? Arraignment on December 15th, yes, ma'am.
I'll see you this afternoon. Have a
Yes, thank you, Mr. Merlater. Mr. Nichols, if you will, just make your way to the podium there. This is cause number 2019-374, State versus David George Nichols. Mr. Nichols, you were here before the court on a motion to revoke your community supervision. I see that the underlying charge is a Class B misdemeanor. And I believe that you were unrepresented when you entered into that plea. Is that correct? At this time, do you want to waive your right to an attorney for the sole purpose of speaking with the state to see what they may be offering as a disposition on your case? If you speak with them and you do not like what they say, you do not want to take their offer, then you can invoke your right to an attorney at that time.
Yes, sir.
Would you like to do that?
Yes, sir.
Okay. Have a seat. I'm going to have the state give me some paperwork that goes over that, and then I'll bring you back up. We'll go over those rights, and then you'll be able to speak with the state, okay? Ms. Heisel, can you assist me with getting the waiver of right to counsel paperwork that they use in the misdemeanor? So that Mr. Nichols, this is a Class B misdemeanor motion to revoke.
Okay.
See where you are.
Okay, no problem.
Thank you. So I'm ready to All right, Mr. Nichols, you are before the court on a motion to revoke for a Class B misdemeanor theft. I hold in my hand a document entitled Waiver of Right to Counsel and Request to allow defendant to communicate with the attorney representing the state. Mr. Nichols, you understand that you have the constitutional right to be represented by the counsel of your own choosing that you can either hire, or if you cannot afford one, then one can be appointed to you if you are indigent. You understand that you have the right to counsel. You also understand that you have the right to waive that counsel, and in doing so, then you can negotiate on your behalf with the state of Texas. You understand that? Yes, sir. And you understand that today, if the court allows you to waive your right to counsel to speak with the state, then if you decide that you do not want to accept what they're offering and you cannot reach another type of disposition, then you can also re-invoke your Sixth Amendment right to counsel. So today you're asking the court to allow you to waive your counsel for purposes of speaking with the state. Is that correct? All right. And are you doing so intentionally, knowingly, and voluntarily? No one's threatened you, forced you, or pressured you to waive your right to counsel to speak with the state. Is that right? All right. Court hereby approves the waiver of right to counsel, and you can speak with Mr. Cox and Ms. Heisel regarding your case, and then you can let me know. Okay. Court's going to stand in recess for about 15, 20 minutes. Allow Mr. Ashmore to continue speaking with the state. Mr. Ashmore, are you ready?
We are ready, Your Honor. Appreciate the court's patience.
And who are you ready on?
The defense would request to call Ms. Munoz's case first, Your Honor.
Ms. Munoz, CR 2183. And Ms. Munoz is set for pretrial today.
Yes, Judge, we don't anticipate there to be any pretrial motions in this matter. We're asking the court to reset it, however, for either a docket call or a second pretrial because there's an unfiled case in the county court F-19-0015 that the state and I have conferred about. We're in agreement to file a motion to consolidate. We'll do that. And then there may be a need for one audio record in discovery, which I don't think has been produced yet because I think it's actually part of her CPS case and not part of any criminal case. But we may want that. That would be our request, and I think we can get all that squared away by December 8th, Your Honor, if that's an available day.
And you're gone the week of the 14th, correct?
I don't know.
Only concern.
There may be a trial that is a bench trial on the 14th and 15th, and I'm uncertain if that is going yet, but my understanding is that it will go.
The only concern with setting it on the 8th is we're already about 40 cases in.
Okay.
And that gets us to capacity in the
Right.
court rather quickly.
The 17th of December, is that a
It's an
possibility?
evidentiary day,
Okay.
but right now we only have 2. So I'll tell you what we'll do. We'll set it on the 17th for docket call. We'll just make use of that date. So Ms. Munoz, once you sign your notice of setting and receive the yellow copy, you're free to go. Tracy Chastain.
We are ready on Mr. Chastain, Your Honor.
CR 2205-206, set for plea today, is that correct?
That's correct, Your Honor. That's my fault. I'm sorry. Judge, I don't think that'll take long. We're also ready for a reset, and we have 2 waivers of jury trial on Mr. Devine.
We'll wait just a minute. And what's the reason that Mr. Chastain's not going into custody today?
Your Honor, his elderly parent, his father, is having surgery. He's the caregiver for his mother, who's also not in the best of health, and he's requested, and the state has agreed for a check-in date in December to allow Dad to come home, convalesce from the surgery, and then that way he can report to carry out the terms of his sentence.
State, you're going to monitor whether or not he appears and take any action if he does not.
Yes, Your Honor, we'll put it on our calendar and check the Monday after his release.
And Mr. Ashmore, you've spoken to your client about the court goes along with this plea agreement, and if he does not appear, you've discussed with him the possibility of new charges.
Probably not in as much detail as I have, but Mr. Chastain has made it abundantly clear he intends to care for his family and report to the jail, and he knows to bring a photo ID so he can check in on that Friday night. And he does appreciate the court and the state allowing him this time to take care of his family and delaying his report to jail by approximately 1 month.
But he does need to understand that if he fails to appear, the state could indict him for escape. And that would be an additional charge.
We're clear on that, aren't we?
Yes, sir. I will report when the court requires, without incident.
I've had, the reason I'm questioning this, Mr. Chastain, is not that I don't believe you. It's just that I've had mixed results with allowing delayed commencement of sentences. I've had some that have done exactly what you're claiming that you're going to do, and then I've had others that I've had to chase across the United States to pick them up at great cost to the county. So that's my only concern.
I would honor that if granted.
Mr. Chastain, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Mr. Chastain, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Very much.
Do you feel like you've had sufficient time to speak with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this plea agreement that you've signed that you do not understand?
No, sir.
Mr. Ashmore, do you believe your client to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
I have, Your Honor.
Mr. Chastain, you are charged by indictment with a third-degree felony offense of unlawful possession of metal or body armor by a felon. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. Are there enhancement paragraphs?
There is, Your Honor. He has a prior conviction for felon in possession of a firearm.
Does that
I
make
believe it's on the indictment.
Does that make a different range of punishment in this case?
Your Honor, I believe it is 2 to 20.
So it'd make it a second degree?
Make sure that that's up in the indictment, but I believe it is.
Indictment says third degree felony, and then it says RFO second degree with repeat felony offender. We have this judgment corrected. It says third degree. This TDC is they're not gonna accept it if I mark through it.
Should have caught that. I'm sorry, Your Honor.
All right, so Mr. Chastain, the state in their indictment have alleged an enhancement paragraph, which, if true, would enhance your punishment, your range of punishment, to that of a second degree felony, not less than 2 years or more than 20 years confinement, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir. That was my understanding all along.
Okay. So at this time, Mr. Chastain, let me ask you, how do you plead to the enhancement paragraph alleged in the indictment? Is that enhancement paragraph true or not true?
As far as I was told, and in the paperwork,
Mr. Ashmore, I'm going to have you take this to Mr. Chastain. I want you to show this
I
document.
agree with it, Your Honor.
No, it's more important to me that you read it, that you enter a plea of true or not true, and that you know exactly what you're agreeing to.
Thank you, Your Honor.
Yes, sir. All right, Mr. Chastain, you've been given an opportunity to review the state's indictment in this case. And so I would ask at this time, how do you plead to the repeat felony offender enhancement paragraph contained in the indictment? Is that true or not true?
That is true.
Okay. And Mr. Chastain, to the criminal offense of unlawful possession of metal or body armor by a felon, how do you plead, guilty or not guilty?
Guilty.
And Mr. Chastain, are you pleading true and guilty because the enhancement paragraph is true and you are guilty of committing the offense?
Yes.
Has anyone threatened you, pressured you, otherwise made you feel like you had to plead true to that enhancement paragraph or plead guilty to the offense?
No, Your Honor.
All right, the court will accept Mr. Chastain's plea of true and plea of guilt. Mr. Ashmore, is there any objection to States 1?
There is not, Your Honor.
States 1 is admitted into evidence. The court will take judicial notice of the defendant's judicial confession with regards to the enhancement paragraph and the guilt. Anything further from the state?
Your Honor, just as we have the updated judgment documented here, Mr. Ashmore, so his client is presented to the court, and the same with the rest of the list.
Thank you.
No objections to the form, first page of the judgment. Thank you, Your Honor.
Anything further from the defense, Mr. Ashmore?
No, I'm sorry, Your Honor. I was making a note so I don't hit this tripwire next time.
All right, Mr. Chastain, upon the court's review of the evidence, the court will follow the plea agreement you have reached with the state. The court finds that there is sufficient evidence to convict you of the second-degree felony offense of unlawful possession of metal or body armor by a felon. The court hereby convicts you of that offense. The court finds the enhancement paragraph to be true. The court assesses your punishment in agreement and in accordance with the plea agreement at 6 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses a $2,500 fine, $290 court cost, $35 reimbursement fee, $180 restitution. The court awards you 107 days credit for time that you have spent in jail on this cause. And the court dismisses under section 1245 of the Texas Penal Code, cause number CR 20206, which is possession of controlled substance less than 1 gram. And also DA 2020-223, which is a driving while intoxicated offense. The court, in compliance with your plea agreement, will allow you to submit yourself to the Van Zandt County Jail on December 18th, 2020, no later than 6 p.m. to begin your sentence. All right, Mr. Chastain, you're hereby remanded to the custody of the Van Zandt County Sheriff so you can carry out the terms and conditions of the sentence. I'm gonna have you step forward with my bailiff to be fingerprinted. Three very important things on December 18th. One, that you show up at the Van Zandt County Justice Center.
Yes, sir, I promise.
Two, that you bring a copy of this judgment with you.
Yes, sir.
Three, you bring a photographic ID with you. If you don't do any one of those three things, then you're going to probably have more trouble in the court. Okay?
Thank you very much.
Mr. Ashmore, what were your fees on? You want to talk? If you'll just talk.
I'll just fill that out.
I didn't
I
know.
thought I circled it, but
Well, you circled it,
she
but
usually does a judgment, but he's going to prison. Yeah. Sorry.
yeah, just if it's because when you circle, it could be up to 4 on those. So if you'll just put that out there, I'll handle that.
I will, Your Honor.
All right, Mr. Devine. This is State versus Justin Lee Devine, CR 20-114, 115. Separate docket call, Mr. Ashmore.
Yes, Your Honor. And the defendant has a plea offer. There are 2 plea offers. One is a 9 TDCJ with no deadly weapon finding on the negligent homicide charge, or alternatively a 10 TDCJ on the tampering charge. Either of those will result in the dismissal of the alternate charge. The defendant has signed and the state has signed the waiver of jury trial on both causes, and we're asking the court for a reset so he can consider the new plea offer.
See the waiver of jury trial. Mr. Devine, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. Are you Justin Lee Devine?
Yes, sir.
And Mr. Devine, have you gone over your waiver of right to jury trial with your attorney, Mr. Ashmore?
Yes, sir.
And it is your understanding that you have the constitutional right to a trial by jury in each one of your cases, correct? No one can take that right away from you, correct? You and only you can waive that right. Understand that?
Yes, sir.
And today you're telling me that you understand that you have the right to have your case tried before a jury, and that includes in that right to subpoena witnesses and also cross-examine and confront the state's witnesses. You understand that?
Yes, sir.
You understand by waiving your right to a jury trial, there's very limited circumstances that the right to a jury could be restored to you once you do this. That means once you make this decision, it's pretty final, absent very limited circumstances. Do you understand that?
Yes, sir.
And are you doing this because it's what you want to do?
Yes, sir.
And no one's threatened you, forced you, or pressured you to do this? Is that right?
Yeah, no, sir.
All right, the court finds that the attorney for the state and attorney for the defendant have joined in with the defendant requesting the waiver of jury trial, and court approves in each case. All right, and when do you want to set this for plea, Mr. Ashmore?
Well, Judge, we're already stacked up on the,
17th?
well, but is that an evidentiary day? Can we do it?
It's an evidentiary day, but if it's going to be a plea, that won't take much time.
Okay, Judge. Same day then, and I'll.
All right, Mr. Devine, I'm going to order you to be back before the court on December 17th for plea.
Yes, sir.
And Mr. Devine would go into custody that day. Is that correct? State? Yes, so I would like for the notice of appearance to say 1:30, and Mr. Devine can appear at the Van Zandt County Justice Center. So just, yeah, make sure that's 9 o'clock's marked through and 1:30 is written down. It is. Thank you, sir.
And Mr. Devine, excuse me.
Yes, we'll see you back on December 17th, 1:30. Mr. Devine, Mr. Ashmore,
Yes, Judge.
we're going to have you appear at 9 a.m. that day.
Oh.
I made a mistake. I do not have a jail docket that afternoon. It'll be at 9 a.m. Okay? Sorry for the confusion on that. Luckily, my staff's here to keep me in check. Yes, he is through. What happened to Kurt Knoll? Anthony Davis. Anthony still. Mr. Davis, have you spoken with Mr. Knoll at all today? Okay, you have a seat.
I'll give it to him.
Will you call, deal with Mr. Ashmore, deal with him, and then deal with Mr. Knoll. Yes.
There's lawyer math. You better double check that.
Mr. Nichols, if you'll come to the podium here. All right, Mr. Nichols, you've spoken with the state, is that correct?
Yes, sir, I have.
And you are not in agreement with their plea recommendation at this time, is that correct?
Not this time, yes, sir.
And you're asking the court to appoint you an attorney?
Yes, sir.
All right, the court has reviewed your affidavit of indigence and finds that you do meet the qualifications for court-appointed counsel. The court is appointing the Honorable Casey Ashmore to represent you in this matter. My staff is preparing some paperwork with that order. Mr. Ashmore's information. This is Mr. Ashmore here. So at this time, Mr. Ashmore, he's set for a motion to revoke. I'll just reset this for December 17th. Give you time to meet with Mr. Nichols about his case and get evidence from the state.
Okay, that's fine, Your Honor. I appreciate that very much. Get a reset form.
So, Mr. Nichols, I want to remind you that you are still on community supervision. Just because this motion is pending doesn't mean that you do not report, that you do not pay, that you do not drug test and do those things, okay?
Yes, sir.
Mr. Ashmore is going to fill out a notice of appearance. You'll sign that. When you receive a copy, you're free to go.
Thank you.
And Mr. Nichols, you can stay right there. He's going to bring you this form. Mr. White, are you ready on Mr. Roscoe Garcia?
Yes, sir.
Go ahead and bring me your paperwork and I'll review that. And then once he signs this, we'll get it there. You ask, that's it. Since it doesn't match. Since I'm asking the premise of this bar All right, Mr. Nichols, you can have a seat.
Yes, sir.
Mr. White, if you're ready. Mr. Roscoe Garcia. All right, Mr. Garcia, if you will, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, let me put your hand down. You are Ivan Roscoe Garcia, is that correct? And sir, are you a United States citizen? And do you understand that any plea before the court today that results in an adjudication of your guilt or a judicial confession of your guilt could have a prejudicial effect on your status within this country. Have you spoken with an immigration attorney or with Mr. White about those collateral consequences?
Yeah.
You have?
Your
And
Honor, for the record, I did tell him, contact an immigration attorney, as that is not one of my strongest things.
okay. And so in this case, you are represented by Mr. White, Jeffrey White. Are you pleased with his representation of you? Have you ever been diagnosed with any type of mental condition? And do you read, write, and speak English? And Mr. White, do you believe your client to be competent today?
He is competent, Your Honor, and is able to make the decisions that he's come up with today.
And you have explained to him the advantages and disadvantages of a deferred adjudication?
He is aware that this would stay off of his record in the event that he is able to complete a 2-year term. He's also aware that he'd be looking at a state jail incarceration, which, as we explained to him, is basically a day-for-day matter.
All right, Mr. Garcia, you are charged by indictment with a state jail felony offense of possession of controlled substance in penalty group 1, less than 1 gram, that carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail prison. Do you understand that? You understand that if the court approves your plea agreement today and places you on community supervision, that if you violate the terms and conditions of your community supervision, and the evidence is brought before the court that proves that the range of punishment the court would have at its disposal is I could sentence you up to a day-for-day sentence up to 2 years. And you want to go forward? All right, Mr. Garcia, then I'd ask you to that charge, how do you plead? Guilty or not guilty? And sir, are you pleading guilty because in fact you are guilty of that offense? Are you pleading guilty because you're guilty of that offense and for no other reason? Meaning you're not pleading guilty just to get a certain recommendation, are you? So you're guilty because you committed this offense. You gotta say yes or no out loud. Okay, my court reporter is here. She's got to take down everything you say. So speak up a little bit louder, okay? And Mr. Garcia, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept Mr. Garcia's plea of guilt. Is there any objection to States 1, Mr. White?
No, no.
States 1 is admitted into evidence, and the court takes judicial notice of Mr. Garcia's judicial confession. Anything further from the state? From the defense?
That's the argument.
And Mr. White, just for the record again, you have spoken with Mr. Garcia regarding his status in this country and the potential effect that a judicial confession to a felony offense could have on his status.
I have, Your Honor, as I said before, any kind of situation comes up, I always try to talk to them.
And Mr. Garcia, you have not spoken with an immigration lawyer, is that correct? Not yet?
I got an appointment when I go back to Houston with immigration lawyer.
And do you feel, though, that it would be in your best interest to have spoken with that attorney before you come into this court and tell me you're guilty of committing a felony offense?
Yes, but I was being sick and I couldn't afford to pay for the lawyer to talk to the immigration lawyer.
You understand, Mr. Garcia, that if I go forward with this and I place you on community supervision, that the federal government could learn of this conviction, or not conviction, but could learn of your judicial confession and potentially come and remove you from the country. You understand that? So you understand the risk associated with telling me that you're guilty and asking me to put you on community supervision. And you understand that you're taking that risk without having consulted an immigration attorney.
Yes, Your Honor.
And that's what you want to do today.
Yes.
All right, Mr. Garcia, the court finds that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement that you've reached with the state. Court will defer a finding of guilt, will place you on community supervision for a period of 2 years. Court assesses a $2,000 fine, $180 restitution, $290 court costs, orders you to reimburse Van Zandt County $35. Court will dismiss under section 1245. Well, the court does not dismiss. I guess the state agrees to reject under section 1245 unfiled cause numbers M19931, which is a possession of controlled substance, and also F19770, another possession of controlled substance in penalty group 1 less than 1 gram. All right, Mr. Garcia, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'm gonna have you step forward and be fingerprinted with my bailiff. After that time, you need to report to Ms. Burns here for more information. Anything else, Mr. White?
I think that takes care of me today.
Thank you, sir. Appreciate your patience with me. Anything to keep you out of there, huh? Mr. Knoll. Mr. Davis, if you'll make your way to your podium, please. Your attorney is going to join us here electronically. Mr. Knoll, good morning, sir. Can you see and hear me?
I can, Judge.
Excellent. Can you see your client, Mr. Anthony Davis? Mr. Davis, if you raise your
I can barely see him, but I do see somebody in the back. Yes, Your Honor.
Mr. Davis would tell you that that is him.
Okay.
All right. And this is CR 2111, and we're set for pretrial today.
Judge, I think possibly the only pretrial I might be missing, and I'm not sure if she had charges filed against her or not for sure, a Deanna Williams. If there's any statements by, I think she would potentially be a co-defendant. There was a CPS investigation. This woman was I guess we'd call her a babysitter with the children. I believe she also tested positive for drug use. If charges were filed or any statements were taken from her, I would need those. I think that's probably about all I would need.
I do not remember if Mr. Knoll is looking for a reset for us to get that information. We'd be happy to do that. Happy to agree to that. Just to double check with our CPS attorney and make sure that that evidence
Did you hear that, Mr. Knoll?
I think there was a, be happy to provide it at the end. I heard some of that, Judge.
I'll turn your microphone on.
Mr. Knoll,
Yes.
I was just saying that if you guys are asking for a reset, we would agree to that, and I will check with our CPS attorney, and if that evidence exists, I will be happy to get it to you.
Okay. And again, if she's, I know that she tested positive. I have a report here. And again, I'm referring to this Deanna Williams, actually for methamphetamine, amphetamines, which would be the metabolites, marijuana, hydrocodone, several things. So I would assume charges were also filed against her. And if she's made any statements to anyone.
Yes, I do remember that I presented their indictments together, but I do not remember off the top of my head if there are any custodial interviews from her.
Okay.
All right, Mr. Knoll, so what the court will do is I will reset this. Let's reset this to, just a second, let me check my calendar.
Judge, I think I'm supposed to be there. I think it's either December 10th or 19th. I always forget.
I've got some availability on the 10th. I got some room on the docket. Are you fine with December 10th?
That's fine, Judge.
All right, so Mr. Davis will set your case for pretrial hearing again on December 10th. We'll let Mr. Knoll and Ms. Heisel work together to see if we can get all of the paperwork that you need. And then we'll move forward with the docket call. All right.
Judge, I think I have 2 or 3 matters this afternoon. I'll be heading over there because I need to pick up some stuff anyway.
Okay, good. Excellent. Okay. All right. Well, we're going to give Mr. Davis the notice of appearance for that new date of December 10th, and then he'll be free to go.
Thank you, Judge.
Thank you, sir. We'll see you this afternoon.
Yes, sir. Thank you, Judge.